subscribe the channel and hit the bell to not miss any update. In this video, I'm gonna tell in brief 100 Supreme Court case laws on constitutional law. In the 100 cases, the case law will be provided on the basis of ratio of the case. First case is Bijoe Emmanuel versus State of Kerala. The court held that the right to free speech and expression also includes the right to remain silent, and that only standing for the national anthem showed proper respect. Rajbala versus State of Haryana. The constitutionality of the Haryana Panchayat Raj Amendment Act 2005 was upheld. The act disbarred persons in Haryana from right to contest panchayat elections on the basis of certain restrictions like educational qualifications, arrears clause, etc. Veeraswami versus Union of India. No FIR against a High Court or Supreme Court judge unless President consult Chief Justice of India and the Chief Justice of India allows it. Delhi Judicial Service Association versus State of Gujarat. Guidelines against arrest of a judicial officer. Permission of district judge or High Court judge required. SP Gupta versus Union of India, also known as first judge's case. Consultation under Article 124 does not mean concurrence. I have made a detailed analysis of the case. I'll put a link to the video in the description. Supreme Court Advocates on Record versus Union of India, also known as second judge's case. Consultation under Article 124 does not mean concurrence. Collegium system evolved. Now the collegium consists of Chief Justice of India plus 2 senior most judges. In re-presidential reference 1998, also known as third judge's case. Collegium means Chief Justice of India and 4 senior most judges. Supreme Court Advocates on Record versus Union of India, also known as 4th judge's case. Primacy of the Chief Justice of India in judicial appointments upheld. National Appointments Judicial Commission Act struck down as unconstitutional. 99 Amendment to the Constitution struck down. Naresh Mirajkar versus State of Maharastra. Judiciary a state while performing administrative functions, not while performing judicial functions. Vishaka versus State of Rajasthan 1997. Guidelines pertaining to sexual harassment of women at workplace. 2013 Sexual Harassment at Workplace Act codifies these guidelines. Sahara versus SEBI. Doctrine of postponement. Postponing media publications to ensure fair trial. Sharaya Bano versus Union of India. Court held triple talaq as unconstitutional. National Legal Services Authority versus Union of India. Transgender as third gender to be given government jobs under OBC category. Shankari Prasad versus Union of India. Parliament can amend fundamental rights. Law under Article 13 does not include a constitutional amendment. I have made a detailed video on this case. I'll put a link in the description. Sajjan Singh versus State of Rajasthan. Question posed: can Parliament amend the basic structure? I have made a detailed video on this. I'll put a link in the description. Golak Nath versus State of Punjab. Parliament cannot amend fundamental rights. Under Article 13, Clause 2, law includes a constitutional amendment. Doctrine of prospective overruling laid down. Diluted by 24 Amendment 1971, law does not include constitutional amendment. As per Article 13, Clause 4 and Article 368, Clause 3 inserted by 24 Amendment 1971. I have made a detailed video on this case. I'll put a link in the description. Keshvananda versus State of Kerala. Parliament can amend fundamental rights, cannot amend the basic structure. Part of Article 31C which barred judicial review struck down. Minerva Mills versus Union of India. Article 368 Clause 4 and Article 368 Clause 5 struck down. Part of Article 31C struck down which gave primacy to all directive principles over fundamental rights. Harmony between directive principles of state policy and fundamental rights are emphasized. I have made a detailed video on this. I'll put a link in the description. Ajay Hasia vs. Khalid Mujib, and R.D. Shetty vs. International Airport Authority. Test for determining other authority under Article 12. A.K. Gopalan vs. State of Madras. Procedure established by law under Article 21 does not mean due process of law. I have made a detailed video on this case. I'll put a link in the description. Maneka Gandhi vs. Union of India. Procedure established by law under Article 21 means due process of law. Right to go abroad, a facet of Article 21. I have made a detailed video on this. I'll put a link in the description. Attorney General of India vs. Lashma Devi. Public hanging is violative of Article 21. K. Puttuswamy vs. Union of India. Right to privacy, a facet of Article 21. Balaji Raghavan vs. Union of India. National awards such as Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri, hereinafter called national awards, are titles within the meaning of Article 18, Clause 1 of the Constitution of India. State of West Bengal vs. Anwar Ali Sarkar. There must be a nexus between the classification and the object of the act which makes the classification. M.R. Balaji vs. State of Mysore. A special provision of reservation should be less than 50%. Caste can be one of the criteria, with other criteria such as place of habitation, poverty, etc. to determine the backwardness. But caste cannot be the sole factor. Indira Sohani vs. Union of India. Reservation in promotion not permissible, though diluted by Article 16, Clause 4A via 77 Amendment. Creamilayer test not applicable to ST/SCs. Reservation beyond 50% not permissible. Caste is predominant test for assessing backwardness. Carry forward rule for vacancies not permissible, diluted by Article 16, Clause 4B via 81st Amendment. Upheld 27% reservation for OBC in public offices. Ajit Singh vs. State of Punjab. Getting reservation in promotion does not grant consequential seniority for ST/SC candidates. Catch-up rule was laid down, under which senior general candidates who were promoted after SC/ST candidates would regain their seniority over SC/ST candidates promoted, though diluted by addition of a clause with consequential seniority in Article 16, Clause 4A via 85th Amendment. M. Nagaraj vs. Union of India. Reservation in promotion can be allowed if three taste factors are shown: demonstrate backwardness, demonstrate inadequacy of representation, overall efficiency of the administration should not get compromised. Held per inquiry in Jarnail Singh vs. Lakshmi Narayan Gupta to the extent that it asks for demonstrating backwardness for ST/SCs, as it goes against Indira Sohani finding that there need not be shown any data for backwardness for ST/SCs. Jarnail Singh vs. Lakshmi Narayan Gupta holds M. Nagaraj per inquiry to the extent that it asks for data to demonstrate backwardness of ST/SCs. Ashok Thakur vs. Union of India. Caste is often used interchangeably with class and can be called as the basic unit in social stratification. Creamilayer principle can be applied to ST/SCs, as they are a separate backward class by themselves. The question was restricted to whether Article 15, Clause 5, insofar as it applied to state institution, violated the basic structure. That part of Article 15, Clause 5, which referred to private, unaided educational institution, was excluded from the scope of inquiry. Court upheld the application of the provision to state institutions. Upheld 27% quota for OBCs in educational institutions. State of Madras vs. Champakam Doraisen. Admission to medical and engineering colleges in Madras in a proportion based on caste and religion were challenged. Court rejected the argument that Article 46 could be used to provide reservation, since directive principles could not go against fundamental rights of citizens, though diluted by addition of Article 15, Clause 5 via the First Amendment, 1951. Mohini Jain vs. State of Karnataka. There is a fundamental right to education at all levels, primary, secondary, and higher. and that the state was under a constitutional mandate to provide educational institution at all those levels. The court held that if government seats are filled by charging X amount, it is the state's responsibility to ensure that all other institutions that are set up with government permission and have obtained recognition from the government also charge the same amount as fees. Unnikrishnan versus State of Andhra Pradesh. Reconsidered Mohini Jain held that the right to education only extends to children up to the age of 14. Private institutions had a right under Article 14, Clause 1, Subclause G that entitled them to complete autonomy. Profit making was essentially for them to flourish. However, laid down certain restrictions, conditions with respect to fee charges by private educational institutions. These conditions included the fee to be charged and the sheet-sharing ratio between the government and private institutions. TMA Pai versus State of Karnataka. Setting up of an educational institution would be an occupation under Article 19, Clause 1, Subclause G. The scheme framed by Unnikrishnan was illegal and unconstitutional. Overruled Unnikrishnan to that extent. State cannot regulate the admission policies of unaided educational institutions run by minorities. However, some rules can be prescribed to maintain academic standards. Minority institutions will have to admit to a reasonable extent non-minority students in their institutions. Islamic Academy of Education versus State of Karnataka held that the state can provide reservation in favor of financially or socially backward section of society. In order to ensure transparency in admission and fee structure, the court resorted to the setting up of committee to give effect judgment in TMA Pai. P.A. Inamdar versus State of Maharastra. The bench was set up to clarify, firstly, the ratio of TMA Pai, which was an 11-judge bench verdict. Secondly, to examine the correctness of Islamic academic case. The court held that setting up of committees to fix fee structure, seats, etc. in private educational institutions run contrary to the judgment of TMA Pai. Hence, overruled Islamic Academy to that extent. State cannot impose its reservation policy on minority and non-minority unaided private colleges, including professional colleges. Incorporation of Article 15, Clause 5 via the 93rd Amendment diluted the ratio of P.A. Inamdar and TMA Pai. State could now provide by law reservation in state as well as private aided and unaided educational institutions. However, minority educational institutions were left out. L. Chandrakumar versus Union of India. Judicial review is a part of the basic structure of the Constitution. Held, Article 323A, Clause 2D and Article 323, Clause 3D struck down as it affected powers of High Court of Judicial Review. Vaman Rao versus Union of India. All laws put under the 9th schedule of the Constitution before the date of Keshvananda Bharati's decision, that is 24th April 1973, will be immune from judicial review. All laws put under the 9th schedule after Keshvananda Bharati will be open to challenge on the ground of violation of basic structure doctrine. I.R. Kolho versus State of Tamil Nadu. Twofold tests laid down to determine the validity of any law put under the 9th schedule. Firstly, whether the law violates fundamental rights. Secondly, whether the violation also results in violation of the basic structure of the Constitution. If yes, the law will be struck down. Held some fundamental rights to be part of the basic structure of the Constitution, but stopped short of holding all fundamental rights to be part of the basic structure. P.Rathinam versus Union of India. Section 309 of the IPC is a cruel and irrational provision, and it may be result in punishing a person again, that is doubly, who has suffered agony and would also be suffering ignominy because of his failure to commit suicide. Consequently, it was held that the section was violative of Article 21, hence unconstitutional. However, the bench did not favor euthanasia. Jian Kaur versus State of Punjab. Right to life under Article 21 is inherently inconsistent with the right to die, as is death with life. In furtherance, the right to life, which includes right to live with human dignity, would mean the existence of such a right up to the natural end of life. It may further include death with dignity, but such existence should not be confused with unnatural extinction of life, curtailing natural span of life. Overrule P.Rathinam versus Union of India. Aruna Schonborg versus Union of India. The Supreme Court issued a set of broad guidelines legalizing passive euthanasia in India. It held that the decision to withdraw treatment, nutrition, or the decision to discontinue life support must be taken by parents, spouse, or other close relatives, or in the absence of them by a next friend. This decision requires approval from the concerned High Court. Common cause versus Union of India. Right to die with dignity is a fundamental right. Passive euthanasia is permissible, not active euthanasia. The difference between active and passive euthanasia is that in active euthanasia, something is done to end the patient's life, while in passive euthanasia, something is not done that would have preserved the patient's life. Court also upheld the validity of a living will. Living will is a written document that allows a patient to give explicit instruction in advance about the medical treatment to be administered when he or she is terminally ill or no longer able to express informed consent. It includes authorizing their families to switch off life support in case of medical board declared that they were beyond medical help. Mental Health Care Act Section 115 decriminalizes suicide. Kihoto Holohan versus Jachilu. Hell, paragraph 7 of the 7th schedule inserted by 52nd Amendment of the Constitution as ultra vires, as it excludes judicial review. Indira Nehru Gandhi versus Rajnaran. Hell 39 Amendment, that is Article 329A, as unconstitutional and violative of basic structure. I have made a detailed video on this. I'll put a link in the description. People's Union for Democratic Rights versus Union of India. Where a person provides labor or service to another for remuneration which is less than the minimum wage, the labor or service provided by him clearly falls within the scope and ambit of the words forced labor under Article 23. Santosh Kumar versus Secretary. Ministry of HRD 1955. Teaching of Sanskrit alone as an elective subject in CBSE can in no way be regarded as against secularism. Indeed, our constitution requires giving a fillip to Sanskrit because of what has been stated in Article 351, in which, while dealing with the duty of the Union to promote spread of Hindi, it has been provided that it would draw whenever necessary or desirable for its vocabulary primarily on Sanskrit. Encouragement to Sanskrit is also necessary because of it being one of the languages included in the 8th schedule. Reb Stanislaus versus State of MP. The right to propagate religion under Article 25 does not include the right to convert by fraud or deceit or allurement, and therefore upheld the constitutional validity of laws enacted by Madhya Pradesh and Orissa legislatures prohibiting conversion by force, fraud or allurement. The link to the part 2 of this video containing 50 more cases given in the description. Thank you so much for giving me your valuable time. If you love the video, do give me thumbs up. If you have any doubts, do comment. I will try in the best possible way to clear those doubts, and do subscribe the channel and hit the bell, as I will be posting regularly such law contents. Till then, Ricky signing off. Peace.